On February 11, 2026, in the Bell County Courthouse in Belton, Texas, a family court judge presided over a contentious child support and custody modification hearing between Mr. Means and Ms. Smith. The case centered on establishing final orders for their minor child, including retroactive child support calculations, visitation schedules, and the use of designated third parties for child exchanges. What began as a routine family court proceeding quickly escalated into a dramatic demonstration of why courtroom decorum rules exist and how quickly a judge's patience can be tested when parties refuse to follow procedural protocols.
If you can find it, if not, I'll just reserve that and we will confirm that. Ms. Briscoe, do you have anything in your notes, ma'am? You muted, ma'am.
I'm muted. I'm unmuted. No, Judge, I do not.
Okay, well, that's about $170 difference, so I need to confirm that one way or the other. So, all right, but anyway, we're on the record at this time, and I'm going to go ahead and, like I say, make the ruling as I have as per this matter. I'm going to go ahead and I'm naming the parties joint managed conservators. I'm giving the mother the right to decide domicile. I'm ordering that the parties, even though it now costs money, I'm going to order the parties to both maintain apt setting up a standard possession order for the father in this matter. I'm going to go ahead and there's a dispute for what kind of credit he should get as far as the direct payments and items that he bought. The court came to an amount that was somewhere between, requested between $900 and $1,800. So what I'm going to do is, this is the one time I can do what Solomon couldn't do. I'm going to split the baby in half. Instead of a $900 credit, I will go ahead and grant that he's entitled to a $1,200 credit against his retroactive child support amount, and in order give him credit, order retroactive child support, and give him credit of $1,200 against that amount. I'm also going to go ahead and require that the father can use a designated agent and pick up and drop off the child, but he cannot use his sister. I didn't write down her name. I left it blank for her. Mr. Means, how many sisters do you got? You had a sister testify last time. Is that correct, sir?
I didn't hear your question, Judge.
Okay, you had a sister here last time during the hearing, and she testified, correct?
Yes, I have two sisters.
All right, but the one that testified last time, what's her name, please?
Keisha Means.
Keisha Means. All right, I'm already.
Keisha Means.
Okay, and Ms. Smith, you can confirm. Ms. Smith and your sister don't seem to get along very well. Your sister, you have a right to use a designated agent, but your sister has absolutely no legal rights as far as any type of service. So I'm going to go ahead and order that you can use a designated agent, but you cannot use your sister Isha. She and the mom don't get along. Prudent to avoid any problems going forward. So anyway, I'm also going to go ahead.
Hey, Judge, I thought we agreed to pick up at the police station, and that eliminates all the problems.
No, sir, you can still use an agent to do that.
But I just can't use my sister Keisha. But that's the closest I got to her. That's the only person that would get my child and drive my child out of town to me.
Sir, that's my court order. Your sister and this lady do not get along, and I don't want anybody having any type of altercations. It's up to you.
All right, Judge. All right.
All right, yeah, figure it out. So, sir, we'll make it work. Anyway, but anyway, that's. But again, I don't want anybody getting into a fight in front of a police station. That's just not going to work well. Anyway, like I said, exchanges as per. All right, and the court will go ahead and waive court costs as to both parties at this time. Okay.
The judge established the parties as joint managing conservators with specific rights allocated to each parent, set a standard possession order for the father, and resolved a disputed credit for direct payments by awarding Mr. Means $1,200 against retroactive child support. The judge also imposed a critical restriction. Mr. Means could use a designated agent for child exchanges, but specifically prohibited his sister Keisha due to documented conflict between her and Ms. Smith. Under Texas Family Code Section 153.071, a parent may designate a competent adult to pick up and deliver the child for periods of possession. But this right is subject to the court's authority to restrict it when necessary to prevent disruption or conflict. Section 153.072 further provides that the court may limit or prohibit a designated agent if the court finds that such restriction is in the best interest of the child. Additionally, Texas Family Code Section 153.252 establishes that the best interest of the child is the primary consideration in any conservatorship determination, and courts have broad discretion to craft possession orders that minimize parental conflict and protect the child's emotional well-being. The judge exercised this statutory discretion by allowing Mr. Means to use a designated agent, a common accommodation for working parents or those living at a distance, but specifically excluded his sister Keisha because she and the mom don't get along. This targeted restriction reflects the court's duty under Section 153.252 to anticipate and prevent situations that could expose the child to adult conflict during exchanges. The judge's reference to avoiding fights in front of a police station demonstrates practical application of the best interest standard, recognizing that even neutral exchange locations cannot overcome the harm of ongoing hostility between adults. Courts routinely face requests to restrict designated agents when family tensions run high, and this ruling illustrates how judges balance parental convenience against child protection. The restriction here is narrowly tailored. It doesn't eliminate Mr. Means's right to use agents entirely, but removes one specific source of conflict. This approach shows viewers that family courts have flexible tools to address dysfunction without unnecessarily limiting parental rights, and that documented interpersonal conflict can have legal consequences in custody arrangements.
Good. I'm sorry, just reading over the last of my notes here. You say something, Mr. Means?
I'm talking to you, man. I'm talking to somebody else.
All right, Mr. Means, then go ahead and mute yourself. And again, the tone was a little aggressive there, sir. So remember.
Hey, Judge, I'm at work, Judge. I
Okay,
talk
I'll just
outside
go
of
ahead.
work. You
Okay, I'm
talk
gonna
out to
go
you. I'll mute myself, though.
I muted you, sir. Don't worry about it. All right. Is there anything else specifically other than the exact amount of child support I need to give you, Mr. Coates, to prepare the order in this one?
Well, Judge, a couple of questions. I just want to remind the court, I think at the last hearing, we confirmed his monthly income at 4680. And I don't think there was a question about the current child support amount at 699 as it was in the temporary orders. The $500 a month was at least one of the terms that was discussed as to what he suggested was credit.
It wasn't. You did not put the state taxes on there. You did not put the state taxes that I pay on there, so you had to go back in, and it changed from 6 something to 5 something when you added the state taxes.
Okay. What state you live in, sir?
I work out of Kansas and Missouri. Both of them charged me federal taxes and state taxes. When he did it the first time, it came out to 6 something. When he did it the second time, when he added the state taxes in, it came out to 5 something.
All right, then, Mr. Miller, that's where the difference is, sir. And I've got
we're professionals now.
And I've got 528.
Actually, it went from 8 to 699.
No, it didn't.
It never was
okay, stop.
I have the email.
Okay, here's the deal. Folks. Miss Briscoe.
Yes, Judge.
Send it over to Mr. Coates, and both of y'all do the math on it. Okay.
Understood, Judge.
All right, and Mr. Coates, send a copy over to Belinda where I can also look and plug my figures in.
Okay, will do.
And instead of having everybody come back in, I'll circulate a written memorandum on what my results are, if they're any different than y'all's. All right, anything else then, Mr. Coates? I'll leave you in a moment, Ms. Briscoe. Thank you.
I think that'll be fine for now, Judge.
All right, Ms. Briscoe, something specifically you need to rule on, ma'am.
A dispute emerged regarding the correct monthly child support obligation, with Mr. Means asserting that state income taxes had been omitted from prior calculations, reducing his obligation from $699 to approximately $528. Rather than resolving this mathematical discrepancy immediately, the judge delegated verification to the attorneys and indicated he would issue a written memorandum with his own calculations. Texas Family Code Section 154.001 establishes that child support calculations must be based on the obligor's net resources, defined in Section 154.062 as income minus specific deductions including federal income taxes, state income taxes, and Social Security taxes. The Texas Family Code does not provide for automatic state income tax deductions for Texas residents, since Texas has no state income tax, but Section 154.062, as A1, explicitly requires deduction of state income taxes for obligors who pay them to other states. This creates a genuine legal issue when, as here, a Texas resident works across state lines in Kansas and Missouri, both of which impose state income taxes. The judge's decision to verify the calculation, rather than accept either party's figure, reflects the statutory mandate that child support be based on accurate net resources. The discrepancy between $699 and $528, approximately $170 monthly, stems from whether Mr. Means's Kansas and Missouri state tax obligations were properly deducted under Section 154.062 ATEA 1. The judge's practical approach of having attorneys collaborate on verification, with judicial oversight via written memorandum, demonstrates how courts handle technical disputes without derailing the broader proceeding. Child support calculations directly impact children's financial welfare and parents' compliance capacity, making accuracy essential. This exchange illustrates that even settled temporary orders may require correction when new information emerges about tax obligations. For viewers, it demonstrates that interstate employment creates genuine complexity in support calculations and that courts have procedures to resolve these disputes without requiring parties to return for additional hearings.
Yes, Judge, that up until this point, based on the November, my client was on an impression that there was a court order about using the app. Contact the Ms. Smith, and he was attempting to do that because we had an agreement about visitation times, the spring break being one of them, which is here. He has been, but she will not answer the phone, so he can't.
Okay, ma'am. Okay, again, there's more than one way to communicate on AppClose. He just needs to go ahead and send any and all. Okay, here's the deal. I've ordered AppClose to be used. This is his visitation coming up, and then he needs to go ahead and if he hasn't, and she's not taking the voice version or the FaceTime version, there's a text on there, and he needs to send text messages or written messages or memos through AppClose, or whatever they call it over there.
I have sent the text the last 5 days. No texts are answered. No phone has been answered. It's spring break. It's my time to get the child. You got AppClose. You can see.
Mr. Here, people, I'm getting ready to put everybody here in jail. Okay, don't interrupt. You'll get the first off, Mr. Means, you have a lawyer, okay? And I'm speaking to your lawyer at this time. Ms. Smith, I had not asked you any questions. I have not come to you yet. But here's the deal. If I've ordered AppClose, AppClose makes a record of all communications. Ms. Smith, if you violate that court order and do not follow the court order as far as visitation and communicating and confirming as such, ma'am, I will fine you or put you in jail. Understood? You don't get to cherry pick.
Can I add? I'm having fun. So I had no problems communicating with Mr. Means. He normally doesn't contact me, and I've been having phone troubles. That's why I had to call in today. My phone would have been.
All right, well, you need to get it fixed ASAP because, again, y'all got to make the arrangements as far as the exchanges are concerned.
Hey, can I say something, George?
Mrs. Means, you have a lawyer. You don't say anything.
The court addressed an apparent breakdown in communication regarding spring break visitation, with Mr. Means claiming Ms. Smith was unresponsive through the court-ordered AppClose platform, while Ms. Smith cited phone troubles and claimed Mr. Means normally doesn't contact me. The judge explicitly warned Ms. Smith that failure to facilitate visitation would result in contempt sanctions, including jail time. Under Texas Family Code Section 153.001, it is public policy to assure that children will have frequent and continuing contact with parents who have shown the ability to act in the best interest of the child. Section 157.001 authorizes enforcement of possession orders through contempt proceedings, and Section 157.002 permits the court to award make-up visitation for denied periods. The 2015 Texas Supreme Court decision in re HS held that a parent's willful interference with the other parent's court-ordered possession constitutes contempt, and courts may impose both civil and criminal contempt sanctions, including incarceration. Additionally, Texas Family Code Section 153.010 mandates that courts include provisions in possession orders for electronic communication between parent and child, and Section 153.015 requires specific findings when restricting such communication. The judge's warning to Ms. Smith, "I will find you or put you in jail," reflects the enforcement mechanisms available under Chapter 157 when a parent cherry picks which court orders to follow. The reference to AppClose's record-keeping function highlights how modern courts rely on documented communication platforms to resolve he said, she said disputes. The judge's immediate intervention when Mr. Means attempted to speak directly, insisting he communicate through counsel, demonstrates procedural enforcement of the rule that represented parties must channel communications through their attorneys during litigation. Visitation interference is among the most commonly reported violations in family court, yet enforcement remains challenging. This exchange shows viewers that courts take these violations seriously and have contempt power to compel compliance, but also that judges expect parties to use prescribed communication channels and follow procedural rules. The judge's simultaneous pressure on both parties, demanding Miss Smith fix her phone and respond, while silencing Mr. Means, illustrates that enforcement is a two-way street requiring both cooperation and proper process.
I got weekends. I got weekends. I don't have to wait to spring break. I got weekends, Judge. I can get
No,
my
you
child on the
don't.
weekend. You
All
ordered
right,
that.
everybody. Well, Mr. Means, you're in contempt. That's a $100 fine to Bell County, Texas. Understood? Mr. Means, when I tell you to go through your lawyer, I mean for you to go through your lawyer. And you want to try for 500, Mr. Means?
Judge, this is
Yes, ma'am.
attorney.
Yes, ma'am. Yes, Miss Briscoe. Sorry about that. But again, your client needs to go through you.
Yeah, and it's been more than patient. My client has not.
Okay, well, Ms. Briscoe,
This
I've
is
given,
because
Ms. Briscoe,
she-
I've given, I want the state to get me a court order, because right now I'm still operating under temporary order. You know how to file a motion for enforcement better than anybody, all right? So, just as good as anyone. So, but the bottom line is, I can't do anything until she violates the court order and a motion for enforcement has been filed. So you know how to get that taken care of. And I'll be happy to hear that and order attorney fees and everything else to go along with it. Ms. Smith needs to get her phone back up and running, but again, obviously he's entitled to get his visitation, and I will enforce that order, ma'am.
Thank you, Judge.
So, Ms. Briscoe, anything else on this one?
No, I just need to accept that I need to make the between me and Mr. Coates is about getting these numbers.
All right.
I'm not sure what Mr. Coates is using as
Do you have Mr. Means's well, we're only in the second month of the year. Do you have his W-2 for 2025?
I do not.
Okay.
We will have this. Hopefully, we'll have this.
Just to be on the safe side, folks, I don't want this to fall through the cracks. So I'm going to go ahead again, Miss Smith. You need to make the children available for the weekends and for spring break as per the court order. The temporary order is still the temporary order has the standard possession order in there, does it, Mr. Coates?
Yes, sir.
Okay, so that's still in full force and effect until the final order comes in. So you have to follow that. The part about the app close, that's going to be in that's going to be in the new order going forward. Dealing with the fact that it now is not to be on the safe side and to make sure everything order to enter whatever's necessary. If I need a second hearing date on this one and we run into a problem, I'm going to go ahead and set this a couple of weeks out, because next week is spring break and I'm not having anything else. I'm not having it. Everybody, it just doesn't work on during spring break. So, I mean, I'm gonna go to you in a moment, Miss. I'm looking at a date that I can move this to, where I can make sure that we got the.
May I, Judge, one other thing?
Mr. Means continued speaking out of turn, despite the judge's direct instruction to communicate through his attorney, resulting in a $100 contempt fine for direct contempt of court. The judge then clarified the procedural path forward. The temporary order remains enforceable, but any violation requires a formal motion for enforcement before the court can award remedies such as make-up visitation or attorney fees. Direct contempt of court disruptive behavior occurring in the court's presence is governed by Texas Government Code Section 21.002(b), which permits a judge to summarily punish contempt without additional notice or hearing when the judge has personal knowledge of the contemptuous conduct. The punishment for direct contempt may include a fine not exceeding $500 or confinement not exceeding 6 months, or both, under Section 21.002, Parts C. The 1998 Texas Supreme Court decision in Ex parte Chambers established that summary contempt power must be exercised with restraint and only for conduct that genuinely obstructs the administration of justice. Regarding enforcement, Texas Family Code Section 157.102 requires that motions for enforcement of possession orders include specific allegations of violation and requested relief, and Section 157.105 mandates that the responding parent be given opportunity to appear and show compliance or contest the allegations. The judge's immediate $100 fine represents classic direct contempt. Mr. Means's interruption occurred in the judge's presence, was personally observed, and directly undermined the court's authority to control its proceedings. The relatively modest amount reflects judicial restraint under Chambers, as the judge initially warned rather than punished severely. Simultaneously, the judge's explanation that he can't do anything until she violates the court order and a motion for enforcement is to file accurately describes the procedural requirement under Chapter 157. Even apparent violations of temporary orders require formal motion, notice, and opportunity to be heard before remedies can be granted. This exchange demonstrates two critical but distinct judicial functions: maintaining courtroom order through contempt power and enforcing substantive rights through statutory procedures. Viewers learn that disrespecting judicial authority carries immediate consequences, while enforcing custody rights requires following proper legal channels. The judge's dual message, comply with procedure to protect your rights, but respect the court's authority in doing so, encapsulates the balance family courts must strike daily.
You gave a number for the credit that you were allowed, but I did not hear the amount of the retroactive support. And this support, is this to be done on a monthly basis, the
Oh,
retroactive?
I'm sorry, the state, what was the retroactive amount that the state determined?
Oh, Jesus, Judge. It was in, hang on just a sec. We had estimated the retro balance at approximately $7,000 because we calculated it at 10 months at $699 as his obligation, which he missed.
Okay, well, I'm only looking at it until the, I was only looking up until the date you started the temporary order. Since since it's an approximation, I'm gonna go ahead and like, see, you said 7,000. I was gonna give him 13. I was gonna go ahead and give him a 1,200 credit. So I'm gonna go ahead and up that to 1,500. So instead of 7,000, we're gonna go ahead and make the retroactive amount of child support at $5,500. Order repayment on that retroactive amount, and an additional $75. So, Mr. Means, we lost you there, sir. He's back in. Mr. Means, I'm gonna withdraw the fine, the $500 fine. But again, Mr. Means, you have a lawyer. You got to let your lawyer do her job. And if you have questions, you need to run them through her, sir. That's just the way this works.
I'm sorry, and
Our order says I get 2 weekends out of a month. I haven't seen my child since December, right? I pay my child support. I don't got no problem paying this money. I don't got no problem paying this back child. I need a relationship with my child. No,
Mr. Means, you're getting ready to get that fine again and getting ready to get some days in jail.
Oh, you just shut up.
Okay, that's it, Mr. Means. 3 days, Bell County, and that's it, sir. You're out.
Yeah.
Mr. Briscoe, the
can't even
client's
do
gonna owe me
nothing
3 days in Bell County jail, and
Just
he
set up
is
the
now
speaker.
removed from the Zoom here.
Judge, that was not Mr. Means.
That was his mama.
That
Well,
was not.
Ask Mr. Means to come back in. Miss Means, you're not a part of this case, ma'am.
Why I'm not? That's my grand.
I removed her too. So tell Mr. Means to come back in. I'll apologize. I thought that was him yelling.
No, that was not Mr. Means.
Okay, but I've removed the Miss Means. She doesn't have a dog in this hunt. All right, let's hopefully ask Mr. Means to just a second, ma'am. Briscoe, see if you can reach your client again. See if he can come back in. Sorry, they may not let him back in because I thought that was him yelling.
Phone numbers. All right, I'm trying to see if I can get him on myself. Henry, I know that was your mother. I took his and all of that straight. I know that she thinks it's going to be a lump sum, but we made it.
The judge ultimately established Mr. Means's retroactive child support obligation at $5,500, reduced from an estimated $7,000 by granting him a $1,500 credit for direct payments and purchases. The court ordered automatic repayment of this retroactive amount, plus an additional $75 monthly. However, the proceeding collapsed into chaos when an unidentified female, later revealed to be Mr. Means's mother, shouted, "Will you just shut up?" leading the judge to summarily impose 3 days in Bell County Jail for contempt. Upon learning this was not Mr. Means speaking, the judge withdrew the contempt sanction against him but removed his mother from the proceeding entirely, emphasizing that non-parties don't have a dog in this case. The hearing concluded with unresolved issues: the precise monthly child support amount pending attorney verification, and the underlying visitation disputes requiring formal enforcement motions. This case illustrates the fundamental tension in family court between emotional urgency and procedural discipline. Mr. Means's anguished declaration, "I haven't seen my child since December. I need a relationship with my child," reflects the genuine pain that drives many parents to court. Yet his repeated inability to channel that emotion through proper legal channels transformed a sympathetic position into sanctions and disruption. The governing principle emerges from Texas Government Code Section 21.001, which declares that the power of courts to punish by contempt is inherent in all courts and essential to the preservation of their authority. This inherent power, recognized since Ex parte Terry, 1888, exists not to punish emotion, but to preserve the judicial system's capacity to deliver justice. When parties bypass attorneys, interrupt proceedings, or allow third parties to interject, they don't merely disrespect the judge, they undermine the very forum in which their rights can be vindicated. For viewers, the educational takeaway is stark. Family courts possess extraordinary flexibility to craft solutions for complex interpersonal problems, but that flexibility depends upon procedural regularity. The same judge who creatively split the baby on the credit dispute and who offered to award attorney fees for enforcement motions ultimately had no alternative but to exclude disruptive participants. The path to a relationship with my child runs through proper process, not around it. If you're navigating a custody or support dispute, remember that your attorney is your voice in court, not an obstacle to it. Before your next hearing, discuss with your lawyer how to present your concerns effectively, what documentation to gather, and how to respond if emotions run high. For those watching who've experienced similar frustration, consider, has following or breaking procedural rules affected your own legal outcomes? Share your reflections and subscribe for more educational court case analyses.